Okay. Well, welcome. We're going to be speaking now about estate administration, and thank you all for being here. The estate administration is something that I've learned over the years that different people have different ideas about what it means. There are a lot of misconceptions, common and uncommon misconceptions. And if you were to ask probably 20 lay persons, what does estate administration mean? What does probate mean? You'd probably get 20 different answers, and all of them would probably have parts that are true, and all of them would probably have parts that are false. So we're going to go through the process. We're going to take you through it step by step so that there can be an identification of what's involved. And in some ways, it's very nice that you folks are here, because estate administration is something that you're not going to be around for when you pass away. When, as I say to clients, when the Lord takes you, someone else is going to be in charge of it. And it's actually probably the epitome of responsibility to try to identify what goes on in estate administration so that you can tell your loved ones or the people who will survive you kind of what they're going to face. And it's not certainly a terrible experience, not a bad experience, and it doesn't necessarily have to be a terribly costly experience if you follow some of the estate planning ideas that we've talked about in other seminars. But it's a process that, in virtually all cases, has to be addressed, has to be undertaken. Kind of the one exception to that is when you have a husband and wife situation, everything's in joint names, and one of the spouses dies. There's typically not a need to open an estate in those circumstances where everything is in joint names. Now, there can be very good estate planning reasons for that not to occur, because there can be tax consequences for the next generation if everything is left in joint names, especially when you're in the federal estate tax bracket. But that's something we've talked about already. But the point of it is that estate administration is something that has to be done in most circumstances other than a first spouse to die with everything in joint names. So let's take a look at what estate administration entails. We do have a question. I'm going to just ask, if you wouldn't terribly mind holding questions for a little while, because I'm going to cover a number of things, and I promise I will get to every question. Is that okay?
No.
You really want to ask that question desperately now?
Yeah.
All right, go ahead.
Would these rules that we see here in front of us, and which I'm sure you're going to cover, apply equally or almost equally in other states?
The question is, do the rules we're talking about here today apply equally in other states? The answer is generally not. Probate and estate administration is very much an individual state-by-state process. And so when we're talking about estate administration here, we're talking about the process in Pennsylvania. Every state has a similar process. You know, the law created estate administration because there has to be a process by which one generation or a deceased individual's property passes in a logical manner to the next generation, and so that the government, as it always does, gets its share. So each state has different procedures that are similar but certainly not identical. They have tax structures which may be dramatically different, and they may have probate fees which are dramatically different. Pennsylvania is a state that has relatively low probate fees, and I may as well talk about that at the outset because I think it's useful to know. Sometimes you hear a lot about the value of living trusts or inter vivos trusts or family trusts. There's a lot of different types of trusts that are sold to people to, quote, avoid probate. In some states, that might be important. It's really not important in Pennsylvania to, quote, avoid probate. The fees typically are in the hundreds of dollars or in the low thousands of dollars. They are not extraordinary, and unlike some states where probate fees can be very, very high, it's really not a consideration in Pennsylvania. It usually costs you more to do the trust than it does to pay the probate fees. And you probably have to pay many of the probate fees under most of the trusts that are provided anyway when people are selling these living trusts, because those living trusts are revocable trusts, and if it's a revocable trust, that property is going to be included in your estate. It's going to be subject, in all likelihood, to some part of the probate process. So it's not something that is typically terribly useful.
Thank
you. You're welcome. You're welcome. All right, let's look at our first PowerPoint here. When a person dies, if they have a will, the executor named in the will has a legal fiduciary, meaning a obligation to, with fidelity, handle the assets of the estate. You have to collect all the assets of the estate, pay debts and taxes of the decedent, and distribute the decedent's property according to the will. Let me talk about a few of those things. Sometimes collecting the assets of the estate isn't as easy as it may seem. With me here tonight are Sarah Locher, who's been a paralegal of nearly 20 years in estate administration, and Leslie Mihalik, who has her master's in tax law and does a great deal of estate planning and estate administration in our firm. Each of us can, I'm sure, tell stories of where you thought you had all the assets of the estate, and then something comes dribbling through. I recently did an estate of a family member. I say recently, it probably was about 6-7 years ago, and a very small stock popped up out of nowhere that we thought we had everything. We had examined it from every way we could. We had the mail forwarded to us. We had all our tax returns, and just, you know, a few $100s in stock that nobody was aware of. All of a sudden, we got notification of it. Collecting the assets of the estate is, 98% is fairly cut and dried. You get the mail forwarded, you get statements from banks, from financial institutions, and you get the old tax returns that show where people got dividends from, where they had interest income. You're able to figure out where the assets came from. But there are some things that are less cut and dried, especially if someone was a little reclusive. When people are reclusive, it can be very difficult to identify where all those assets are. Pay debts and taxes of the decedent. And obviously it's important to whomever is going to administer the estate to make sure that those debts and taxes are paid for, because that personal representative, the executor for someone who has a will, or executrix, or the administrator or administratrix for someone who dies intestate, can have liability if they don't pay debts and taxes. And we'll talk about those a little bit more. And third, distribute the decedent's property according to the will. Or the intestacy laws. As we often say, if you don't have a will, the government will write one for you, and that's the intestacy law. And usually, again, that's fairly straightforward where the property goes. But, there are plenty of circumstances in the law books where ambiguity exists as to who will take property and what share they will take. Our office is working on a couple of those just now, where there is some ambiguity under wills that were drafted, 20, 30 years ago, and people have died and offspring have died, and it's new members of the family were adopted, and it's unclear as to who was intended to take under the will. If there is no will, an administrator, usually a relative of the decedent, will take on the same duties as above, but distribute the property according to the laws of intestacy. And that's what we indicated. It's the administrator if it's a male, administratrix if it's a woman. The executor or administrator becomes the overseer of all probate property and has a legal duty to keep the property viable, or in the case of securities, marketable. First of all, and the important distinction, the executor or the administrator, and forgive me if I use the male gender at times, sometimes I'll try to mix it up with the administratrix and executrix, they oversee the probate property. They don't oversee property that passes outside of the will. And that's, I think that's one of the misperceptions, and we deal with that in our office all the time when we do wills for people. So often people think everything you own passes under your will, and that's just not the case if you own things like jointly held property, with right of survivorship, as most people do if they're husband and wife, if you have life insurance policies, if you have retirement plans that have a death beneficiary. All of those things are not probate assets. You might have to pay taxes on them. There may be inheritance tax or there may be federal estate tax depending upon the nature of them. For example, life insurance is, unless you hold it in a life insurance trust, is part of your estate for federal estate tax purposes. Retirement plans can be part of your estate for Pennsylvania and federal estate tax purposes. A portion of jointly held property, if it's not held with a spouse, can be taxable under those estates. So, but it's not part of your probate estate. It's not what the administrator or executor takes control of and distributes. Why? Because they're distributed either by what we call operation of law in the situation of jointly held property, where if you hold a deed with somebody, a husband and wife, for example, it passes automatically. It doesn't go through your estate. It doesn't go through your will. It passes automatically to the spouse. Now, under both the federal and the Pennsylvania death tax statutes, you can pass anything to a wife free of tax. It's the second to die, as we've seen in other seminars, where the tax bite comes along. But again, the life insurance, paid through your estate. It gets paid to whoever you designate in your beneficiary designation. Same thing with retirement plan. If you have a retirement plan that has a death beneficiary and you name someone, that doesn't go to the executor for distribution. That goes directly from that retirement plan to whoever is going to be receiving that property. Now, as we say on the PowerPoint here, the executor administrator is the overseer of all probate property and has a legal duty to keep the property viable, or in the case of securities, marketable. So let's say it's real estate. That executor or administrator has an obligation to make sure that that property is taken care of, that it remains something that could be sold and used as an asset, maintain insurance on it, and in the case of someone who lives alone and dies, it can be very difficult to keep insurance on that property if it's vacant. So that's, you know, these are things that an administrator or an executor has to be thinking about. And when you take over an estate, you do need to move with at least deliberate speed. There was a great basketball coach who has a quote that I sometimes tell my clients: be quick but don't hurry. You know, you don't have to be in a mad rush when someone dies to start probating the estate. Make sure that property is protected. You got to make sure the insurance is paid, that it's up to date. You have to make sure that if you've got fluctuating market conditions, that you may want to liquidate assets and make them into cash. You have to get good advice and move on it with relative dispatch. Again, it's not like, you know, you've got to go from the cemetery to the lawyer's office, but you don't want to be putting it off for months or, frankly, even weeks. You do want to move on it with relative speed.